Our sixth session, which is on experience sharing, and we have members from the user community, corporate leaders and senior government officials who have been in the thick of high-level disputes, sharing how arbitrations have worked for them as an ADR mechanism and whether other ADR mechanisms have fared better, and if not, then why. They will also share with us a lay perspective on their expectations from the courts, the state, and the arbitration tribunals. And I'll very quickly introduce our panel to you. We have Ms. Rohini Roy, who currently heads the legal operations of the international operations of the Maharatna Public Sector Undertaking, Bharat Heavy Electricals Limited, across the company's widespread operations in 72 countries with varied jurisdictions over the world. Dr. Raghupati Singhania, Chairman and Managing Director of JK Tyre and Industries, pioneers of radial technology in India and leaders in the Indian tyre industry, and the manufacturers of several well-known brands like the JK Tyre, Vikrant and Tonal brand of tyres. Mr. Harshvardhan Neotia, President FICCI and Chairman of the Ambuja Neotia Group. Operating through several companies, the Ambuja Neotia Group covers the entire spectrum of the real estate industry, including housing, hospitality, healthcare, and education. Mr. Aditya Ghosh, CEO Indigo Airlines, a law graduate from the University of Delhi. Mr. Ghosh has worked at a leading IP firm as a lawyer for 7 years on different assignments and was later appointed as the general counsel at Interglobe. And despite not attending business school or working with an airline before, he went on to turn Indigo into the most profitable airline in India and the fourth largest low-cost carrier in the world. Mr. Raghav Chandra, Chairman of the National Highways Authority, responsible for the development, operation, and maintenance of national highways across India, the largest ongoing infrastructure program in the world. Mr. Chandra brings with him a 3-decade-long innings in the Indian Administrative Service, where he has served in important positions of the state and central governments. Our moderator is the chairman of the International Chamber of Commerce and the founder and chairman of Bharti Enterprises, one of India's leading conglomerates, with diversified interests in telecom, insurance, real estate, agri and food, besides other ventures, Mr. Sunil Bharti Mittal. So I hand over to Mr. Mittal to conduct the session.
Thank you, Rini. A very good afternoon to all of you. I am acutely aware that this is the last panel of the day, and we'll try to make it as lively and interactive as possible. I am here today not in my capacity as a businessman, but as the chairman of International Chamber of Commerce. And many of you had the pleasure of hearing Alexis Moret, the ICC's head of Court of Arbitration, based out of Paris, a place which I frequently visit as in my new capacity as the chairman of ICC. And I'm also very familiar now with the process of arbitration, and particularly how distinguished ICC position is on the global arbitration space. India and India's leadership today desires India to now join the ranks of countries which have very solid ecosystem for arbitration. And indeed, as a businessman, I have had experience of long delayed processes of arbitration, at times government enforcing their own choices of arbitrators. And in my early life in the telecommunications sector, the licenses came out with one-liner that the government reserves the sole right to appoint a single arbitrator. The people had no choice. In fact, I have a very distinguished and diverse panel here with me today. And I will be posing some of the questions and then be opening the floor to all of you to find out how some of our panelists feel as to the development of arbitration in India, and more importantly, the thrust that our government is now giving in truly making a dramatic change in the Indian arbitration ecosystem. We have had tremendous amount of tailwinds in the form of several Supreme Court judgments which help in now establishing and entrenching arbitration ecosystem in India. I was delighted to see that the MCIA, the Mumbai Court of International Arbitration, the Mumbai Center for International Arbitration, has now opened up. And there are very strong efforts underway to start the Delhi Center as well. The IC ADR, I believe a wonderful building exists in Vasant Kunj, which just needs to be put into action, brought with a new life and vigor. And I hope under the leadership of Chief Justice of India and this government, we'll be able to see Delhi also becoming one of the centers for arbitration. Typically, in situations where Indian companies are dealing with foreign companies, contracts with foreign suppliers, vendors, joint ventures, or for that matter, MNCs coming into India and seeking business opportunities, have traditionally shied away from subjecting themselves to Indian arbitration rules. In their opinion, they were better served in their jurisdictions which were more neutral and, if possible, their home countries. Equally, the Indians always fought back in not allowing their jurisdictions to be acceptable, and we ended up either being in London through LCIA or ICC Paris or SIAC now, which has been gathering a lot of momentum for Asia, in particular Indian companies, which is set up in Singapore. I personally believe that the amendments that were made last year have brought tremendous momentum to what can be done here in India. And India, with its size and scale, deserves to have its own strong ecosystem, such that we should see countries from South Asia, companies established in SAARC region, start to look towards India for low-cost, effective, timely, and expeditious arbitration processes. I would like to add the Indian courts, we have always heard, are very heavily loaded, and it will be, I am sure, the desire of the courts to see that such alternate dispute resolution mechanisms are taking shape and serving the needs of the business community. A number of activities, as I mentioned in the past 1 or 2 years, have allowed us to be much more optimistic and hopeful. And I believe that in the coming months and years, India should emerge a very important center for arbitration, both for domestic as well as cross-border. With that, let me now turn to my fellow panelists and ask Mr. Chandra, who is the chairman of NHIA, as to how does he feel that he can give comfort to the private sector, that they, while negotiating contracts with government, can force some of the issues that they would want to have and not completely be at the mercy of the government bodies, which will inevitably try to push for clauses that suit their own needs in terms of any disputes that come forward. Importantly, I don't see any of the road contracts that have been executed between the government and the private sector which do not end up in disputes. Construction, contracting by its very nature have escalations. Almost all contracts end up asking for escalations. I don't see any officer which will have the courage or the power to sign an escalation of few crores, or in some cases several 100 crores. The safest bet for him or her would be to let the process of arbitration and the courts play its part, so that his own career is protected and he's not subjected to either CVC or other pressures that he may have, which may completely destroy his career. So how do you give a fair deal to the private sector, and how do you deal with the escalations?
Thanks, Mr. Mittal. Contracts by their very nature are never perfectly complete or cast in stone. And to imagine that they would be perfect would not quite be the correct thing to say or do. And I understand that the latest Nobel Prize for Economics is based on this analysis that contracts need to be perhaps renegotiated, or that they can never be perfect. And likewise, we've had a situation where the magnitude of the problem in the road sector in particular has been enormous, because it was the erstwhile Planning Commission imagined that the concession agreements could be cast in stone and would be perfect. But that has not happened. And which is why, to just give you a sense of the magnitude of the problem that beholds us, we have already arbitration cases going on in 130 matters for an overall envelope size of about 20,000 crores. We've had previous awards for 13,000 crores, out of which we've settled for about 5,000 crores. Another 8,000 crores have yet to be settled. These are technical disputes. When it comes to land acquisition issues, which are more on the soil and a more disaggregated, decentralized level, we have some 20,000 odd arbitration cases going on the field. So there's a huge task before us. Nevertheless, the latest decision of the government at the highest level, which was steered through the Niti Aayog, that 75% of an arbitral award could be given against bank guarantees and then the litigation could go on, is, I think, a correct step in the right direction. But at the same time, it poses a challenge to an authority like the NHAI, because you have to ensure that going forward, arbitral awards are done with the highest level of neutrality, to ensure transparency and to ensure that awards that are passed are not one-sided awards. And to that extent, we have to ensure that they have to be holistic, where they take on board the viewpoints of both parties, and that neutrality should be the cornerstone of the award. Why have officers been unwilling to respect awards in the past? There have been several curious cases. First of all, is a situation where private parties go and challenge the matter ab initio before a court of law, only to create a psyche where the authority feels sort of pushed into going in a particular direction. So we've had several instances where even before trying out the arbitral stage, people have directly gone to the court of law, and I think that is one thing which should be discouraged by the courts. They should not entertain any matter on a contractual issue, especially when there is an arbitral clause which is embedded into the contract. We've had situations where courts have given a stay without even hearing a matter, with due respect to the honorable courts, because we are talking in an academic forum, only to say that, well, how does it matter if it's a stay for a few days? You can come back with your application later. Officers have been scared of taking decisions, and this is why the cabinet ruled for a 75% payment on arbitral awards, only because they are afraid that there is no ecosystem today where the CVC or the courts or the various authorities think along the same lines, and therefore there is a need to develop more commercial understanding of contracts, of corporate matters, of commercial matters. I am aware of a case where a matter is, the High Court ruled that in a land acquisition case, when the authority and a private party negotiated between a willing seller and a willing buyer at rates which were well above the circle rate, why should a criminal investigation not be conducted? Because they have not gone through the compulsory land acquisition route, which could have given the award at a lower rate than the circle rate. So such situations jeopardize, and I think as a nation we need to develop and evolve mechanisms by which commercial decisions ought to be decriminalized, and we ought to be able to create an ecosystem where arbitral awards are respected. There is greater neutrality, and for this, HR is, I think, at all levels of the several pillars of the Constitution needs to be focused on. More important is the fact that is to recognize the fact that a good arbitral award and a honest, neutral arbitral proceeding is a win-win for all parties, for the authority or the government, for the private party, and should be able to save the courts undue wastage of time. So that is briefly the...
Well, thank you, Mr. Chandra. I think one of the important parts you've touched upon is in some sense an acceptance that a government officer works under a very difficult situation where he could be challenged for some of his decisions which may not involve corruption but may involve some kind of ambiguity in taking a decision. It could be a lack of judgment, or in hindsight, when you look back, he could have done a better job with the decision. I mean, this is a very difficult part. And inevitably, I think we heard Mr. Jaitley yesterday, the finance minister, talking about finally bringing the amendments to the PCA in the winter session. And I hope that that can be expeditiously taken up by the Parliament so that many of the officers who are online can take decisions boldly without any fear of being prosecuted. Let me turn to Harshvardhan Neotia, President of FICCI. India set up its Arbitration Act in 1940, and it was also a signatory to the New York Convention of 58. FICCI set up its own arbitration panel called FACT, I believe. Would you share with us why India has not been able to progress, and what were the impediments for you at FICCI that we could not really demonstrate efficacy of the arbitration process?
Well, I think this has been covered to some extent in your own introductory remarks. The cost and time that arbitration processes took was really one of the major reasons why the Indian Council of Arbitration that was set up under the aegis of FICCI was not able to gather the kind of momentum that should have happened in a country of our size and with all the issues that are coming into the courts. We have seen this new Arbitration Act, and I think it's a step in the right direction. There may be some issues that people are concerned about, but the fact that it is moving towards putting a timeline, and I hope also in terms of costs it would be more reasonable, that would certainly make for a good ecosystem to encourage arbitration. I'd just like to also add that India as a cultural society has had a long tradition of informal mediation arbitration. I remember hearing from my great-grandfather that in the olden times, a community respected leader was often invited to settle issues, particularly commercial issues in the business community, amicably between warring groups. And it was in a sense some kind of an informal mediation or arbitration. And those were respected. In fact, many of those contracts were even verbal contracts, and there was hardly any document to rely upon. But through the evidences and through the discussions that happened in the room, very often amicable resolutions used to come through. And there's not to say that some disputes didn't linger and go to the courts and other places, but with the number of complex issues that will come up in our country with a growing economy and the fact that we will even grow faster and bigger, I think there's a very, very good case for improved arbitration mechanisms. And perhaps I would go to even add that maybe including mediation as another process in this would be also helpful and maybe more cost-effective and flexible. A very important feature that we at FICCI have noticed in arbitration is the fact that it is a confidential process, and that is very important at times in commercial matters. So the confidentiality of this should become a very, very important reason why people should opt for this rather than the normal court and litigation processes. So it's not to say that every matter can be resolved through this, obviously not, but this could certainly speed up the logjam that we have in our courts. It could improve the entire ecosystem of doing business, and I think FICCI feels extremely optimistic that with the new law we should be moving well on track in this area.
Thank you. I will turn to you, Mr. Singhania. International commercial disputes involving India have been on the rise. And if I may point out some of the recent cases, Vodafone, Devas Antrix, Tata Docomo, Cairn Energy, all of them are bringing a lot of attention to India in terms of India's capacity for arbitration and post-awards of such arbitration awards, how the courts are reacting. In your opinion, what can we do here in India to establish ourselves in the eyes of global majors for them to be comfortable to be subjected to accepting Indian arbitration process?
First and foremost, we'll have to put the structure right, make the whole arbitration process strong and credible. Today, as a country, we suffer from the credibility. Whenever there are contracts, most of the parties do not wish to be arbitrated upon in India and opt for international lands. And there, some steps have been taken. First, of course, is this amendment, which will go a long way, I'm sure, of course, subject to certain improvements there. But more important is, we must create an infrastructure of the arbitration centers, as has been set up in Bombay, and now in process in Delhi, and also in Bangalore. And if we set up those processes and prove our credibility as a nation in terms of fair arbitration proceedings, and more importantly, within a stipulated time, I think we'll regain our credibility. And it will take a couple of years, it will not happen overnight. In a couple of years' time, we should be able to establish ourselves. As a matter of fact, I would plead that we as a country should try to create India as an arbitration center. We should promote it by deliberate effort, by creating centers, by establishing a neat process, by having more meaningful and logical disposition of cases, and thereby giving confidence to the international community. And in course of time, I'm sure, as Singapore and London and Paris have become centers, we should be able to establish ourselves as a credible center for arbitration.
Well, I'll turn to Ms. Roy of BHEL. Generally, there's a lot of complaint that there is a conflict of interest, especially with regard to setting up your own internal processes and people to arbitrate between issues concerning yourself, BHEL, and the vendor community. And I spoke to some of them in the last 48 hours, and their view is that the independence is always a question mark as far as the officers that are appointed from within. How do you deal with this conflict of interest, and how do you give confidence to those vendors who generally are, at the mercy of your final decision?
The international community has undergone a very, very sea change in terms of dispute resolution. I do think that when we started out being government undertakings, there was a preference to appoint our own people. Perhaps there was a trust issue, there was a bond which we created. The international community, especially in the large public sector undertakings as ourselves, also believe that the sentiment in dispute resolution is actually to preserve relationships and not to destroy relationships by disputing. Unfortunately, the levels of animosity that we have witnessed in proceedings have been far too non-commensurate to our expectations, maybe because of a lot of hardball advocacy that goes on between the lawyers. And therefore, there was initially a preference for selecting our own people. Another very important aspect was also because technique cannot really be divorced from the legal aspects of a case. And for any discipline which is essentially into technicalities, for example, our enterprise is very much into, it's also a manufacturing body. So the technique and the history and the story of the machines, it just could not be delinked from the legal aspects. Now, when we see arbitrators who are of the legal background, they are often very unemotional to technique. And what happens in those proceedings is that we lose out because of the lack of comprehension in technique. So there was a preference, yes, but over the last 7 or 10 years, as the business has grown internationally, we have tried to limit the usage of our own personnel in such businesses. We are now encouraging arbitrators of more legal backgrounds than business backgrounds, because we feel that at the end of the day, when there is a written award, it has to reflect legality and logic. But I think that where we are heartbroken is that the number of disputes that we've done, institutional or ad hoc, more institutional internationally than ad hoc, have not left us with a very good flavor of trust in the entire process. So essentially, I think while it has assumed certain characteristics of litigation, which is being of cost, time, expenses, also the value and the qualitativeness of the adjudicators, I do believe that in a fair hearing, time and cost, these are issues which naturally resolve themselves. So an unsatisfactory proceeding, however, no matter how short and how inexpensive, is just always too long and expensive. So the challenge which is faced by arbitration today, especially for PSUs, whether we use retired personnel or not, is actually to meet the parties' fundamental expectation of a well-balanced, fair proceeding, which I'm not sure how far. So I think the battle really is to restore that faith in the game, because we as an institution have now started preferring other means of dispute resolution, irrespective of what personnel or the quality of adjudicators that we use.
Thank you. I will turn to our last panelist on this panel, Aditya Ghosh, CEO, Indigo Airlines. Aditya, you are in a very complex industry. It's a very specialized industry, and more importantly, it's full of cross-border dealings. Give us your impressions about how you have handled issues around leasing of aircrafts, international rights, etc. And what are the pressures that you have faced and how you've been able to resolve them?
Very true, Ms. Mittal. Ours is a very complex business. Almost every aspect of it is cross-border. Other than flying the customers from a point A to point B in India, everything else, whether it is a fuel supply contract or a lease with a lessor or aircraft manufacturers or engine manufacturers or maintenance contracts, everything is cross-border. Now, having said that, there is a certain advantage to our business too, which is that there are only a few players. There are, give or take, only 4 large aircraft manufacturers. There are only 2 engine manufacturers. Maybe amongst the large lessors, maybe 20 of them make up 95% of all the leasing of at least commercial aircraft in the world. So now when that happens, the general tendency is something that Ms. Roy pointed out in her business, is to preserve relationships. If you have daggers drawn at each other, the manufacturer knows he has to come and sell the planes to the same guy, and we know we've got to stand at his doorstep when the next 100 plane order comes up. Now, so that forces people to take a more pragmatic view on navigating disputes and navigating issues and challenges that come up in long-term contracts. There's one other thing, I think, and which will probably go to some of the questions that you were asking, Mr. Mittal, and it's probably similar to telecom as well. I think there is also a need to break from the past. There was a certain law in 1940, 1996. The jurisprudence in India has developed in a certain way. Law firms and advocates and lawyers have approached disputes in a certain way. Parties to disputes have approached the same problem in a certain way. And I think that there is a need to kind of break from the past and see, how do we get the deal done? How do we move the ball ahead? And that has to be towards, with a mindset that it is after all about dispute resolution. It is after all about mediating and after all resolving a dispute rather than continuing it. And I think there is a responsibility on the institution, responsibility on the arbitrators, responsibility on the lawyers, as well as probably responsibility on the parties to a dispute to take it in that positive sort of a manner. Fortunately, we ourselves have not had to experience it personally, but we know till only a few years ago, 1 or 2 large airlines, when they were going down, there were issues between lessors and airline operators and airport operators. And I must say that the government actually played a fairly facilitative role in giving confidence to the lessors or the owners of the airplanes that they could recover their assets pretty quickly, and was able to kind of instill that confidence, which took those clouds away from especially the airline business, which is anyway seen as a dog business, and I don't know why people do it, and so on and so forth. So I think that's the way we look at it in our industry.
Let me open another front here for discussion and seek some of your views. And maybe the first point that I would like to make here is, which I can ask both Mr. Chandra and Raghupat Singhania to, give their comments on, as to what do we need in addition to what has been done in the last few years by the high courts and Supreme Court of the country to further the cause of arbitration being a preferred mechanism for contracts, for joint ventures, for private sector dispute settlement, in effect the alternate dispute resolution becoming the mainstay. And let me just point out some of the landmark rulings of Supreme Court, which have declared Indian arbitration law to be seat-centric, curtailed Indian judiciary's powers to interfere with arbitrations seated outside India, referred non-signatories to an arbitration agreement to settle disputes through arbitration, defined scope of public policy in foreign seated arbitration, and determined that even fraud is arbitrable. So a lot of effort has been made by the courts, in particular the Honorable Supreme Court, which I've just pointed out. What more needs to be done by the judiciary?
Sure.
One small observation on that, and which is something that we need to look at and which perhaps needs to be done through a legal framework, which is that work should not stop. So if there is a dispute, even while the dispute is getting resolved through either a conciliation proceeding or through an arbitral proceeding or through the court of law, work should be allowed to be continued. And I think this is something which needs to be both built into our agreements, built into our framework of law, and also respected by the honorable courts, that sometimes it happens that a concessionaire or a contractor is defaulted and the dispute is not yet resolved. Unfortunately, it goes into a limbo. Whereas, even while the dispute is being resolved, work should continue. We should be allowed to substitute, and even though the contract may not clearly provide for it, but that larger ambit of support, that ecosystem needs to be built in. We are, of course, trying to move towards improving our agreements to ensure that this is categorically brought in, but until then, this needs to be supported.
Of course, the commendable interventions and observations by the apex courts are very important, and they will go a long way in easing or simplifying the process. But let's remember that why did the arbitration or this alternate dispute resolution method was thought of? One of the biggest issues in front of the industry was time and cost. There were 10 years, 8 years, 12 years arbitration running, and with enormous costs being incurred by traveling, stay, executives' time, etc., etc., etc. So the latest amendment has certainly addressed those issues to a great extent by limiting the time period of 12 months and then another maximum 6 months extension. But 18 months and 6 months. But it does not lay down the overall time period. To my mind, the court should lay down overall time period. That let us say, I am saying no more than 24 months. 18 plus 6 I am taking for the time being the same timeline set down. And in addition to that, we find that arbitrations are being challenged traditionally. And to take care of that litigation, which is, again is a prolonged affair, and we had no cases which have run into 8 to 10 years and still not out, I think further period of another, let us say, another 12 months or 24 months may be laid down as the uppermost limit. So therefore, let us say 4 years maximum. I would opt for 3, but let us say even for the sake of transition, so until unless we lay down some overall time limit, the arbitration will not become, so to say, consumer friendly for you and me and as a corporates and the world as a whole or contracting companies. And second, of course, is the question of cost, which is very much related to time. Of course, there is a schedule of arbitration fees have been attempted to be laid down, but experience has it that there are a number of disputes and people do not accept those fees and they have to be negotiated. So I think we'll have to find some teeth for that purpose.
Just picking up from your point of limitation of time or putting strict timelines, let me open another question, and I'll start with Ms. Roy here, and then maybe I can have both Harsh and Aditya also, add to that. I was having a discussion with Alexi Moray, who is also present here, the head of Court of Arbitration for ICC. One of the biggest issues that he was protesting against the amendments that have been made is that India has now defined that after 12 months and another 6 months of extension, you necessarily need to go to a court to seek further extension. And he was quite passionate about it, that this will not allow high quality arbitration panels or courts to come into India to work. And my argument back with him was that I think this is a pretty good idea, that you can define a time frame in which you can nail down an arbitration to be completed. And there must be a serious reason for it to go outside that 12 plus 6 months. And his view was, out of experience that ICC has had over long years and decades, that there are complex arbitration proceedings which inevitably will take much longer time. So where would you like to bat on this one? Would you want stricter timelines, which I think most of us would want to have as business people? Or should we have flexibility available to the panels to extend their period?
I think this raises a lot of pertinent questions, because I think while it is extremely important to have very strict timelines in order to economize, we also have to consider the practicality of having the courts interfere in a process, because I think that in case I'm able to give, let's say, about 24 months to a dispute, even then the question really arises: A, does it finish? B, when it goes to court, how much of interference am I looking at? I don't think sealing the remedy is necessarily a great move, because you would also want a sort of margin where these disputes could be finished. We deal with very complex arguments, and if there are lawyers and a legal-based adjudicator, this is bound to take time, because technique is very difficult to appreciate, and no matter how many expert witnesses that we may be allowed to put up, it is often not completable in that time frame. But I think that just expecting the court to be able to limit the timelines is not fair, because a lot of the procedural aspects of this arbitration is what takes all the time. For example, I think the very fact that there is a lack of any model law in arbitration, where you cap the number of documents filed, you cap the amount of time that you can take in evidence, you cap the amount of depositions or submissions before a court. I think there must be a procedural cap in terms of written procedure, which acts as a model for such arbitration proceedings, that can perhaps curb time more effectively than just giving a time frame and then saying that we have more time to adjudicate over it. But essentially the game plan would be limiting the number of procedures that are present it's the procedures which are more time consuming.
You want to add to that?
I don't know, I somehow am in your camp, really. We're clearly overcompensating for what has happened in the past, and the way which the business moves these days, the speed at which business moves these days, the market opportunities, I'd much rather have a speedy sort of gun on my head sort of a situation, and force parties and lawyers and arbitrators to really deliberate seriously. Not for a moment am I saying they should overlook an important aspect of the dispute, but really, I'm a great one for having deadlines, and then there is always the court to interfere if there was indeed something that was grossly overlooked, and so I'm really in your camp on that one.
That's a quick one.
Yeah, I think I generally agree with the idea of a time limit, but I would certainly feel that the need to have a window to go to the court in case some things don't work out within that time limit should be there. I think another way that we can see that the pain is somewhat contained is if the arbitration could allow for interim awards which could provide some relief to the various people concerned, while the final might take a little longer to come to. So that could be another way of looking at it.
Please allow me to read verbatim some comments that I received this morning from people who are heavily into arbitration. This is one of the leading contracting companies in India. The CEO wrote to me this morning, the main problem in Indian arbitration is the time taken. We reminded a panel as to why our case has not been taken up for 4 years. The answer was that we forgot it as it was 4 years old and we needed to be reminded. The amendments last year should address these issues. This is one comment that I got this morning. And another one was, unfortunately, on the same, on a body that I had as the chairman of ICC, it says, international arbitration -ICC just takes way too long. We are waiting already 5 months for an award. Time allowed is 3 months. They ask for another 3 months, and the costs are ridiculously high. So this is, I hear this almost all the time, and I'm sure the legal fraternity who's here, who deal with their clients almost all the time, hear this, that it takes a lot of time. So I really don't know where the balance is, and honestly, I'm not an expert. I'm just trying to facilitate this discussion. But it'll greatly help if we find the right balance, because as I was talking to Mr. Chandra earlier, all arbitration awards then end up going into courts, and some of these awards are stuck in the court for over 10 years. And many cases could be such that the companies may have gone bankrupt by this period of time. We need speedy, and the whole idea of having an ADR is to have a fast-track mechanism. So Alex's point of view that we need flexibility in increasing the time from 18 months to something else may well be required, because there are complex arbitration issues, but there should be still a definitive timeline. And when these awards go into courts, there, of course, I personally believe that these awards should act as an ATM, which means you can cash these awards as soon as you can, other than if there is a serious point of law or there is an established process failure. Otherwise, the court should generally not intervene. We are seeing this happening in SIAC. We are seeing this happening in Paris ICC, in LCIA. Awards, once granted, are fairly easy to encash. So, please.
The example which you gave, the note you received, is very telling. Even in a process international, I'm referring to your ICC award, 5 month time is considered too long, or 8 month time is considered too long, and there is a plea that should be expedited. And here we are, sitting in our Indian circumstances, where 8 to 10 years have been the norms, so to say, and if we are attempting to suggest 12 months or 24 months, even that is considered too tight. I think we'll have to change mindset as a nation, as we are trying to do in everything. You and I do business, we are trying to change our mindset and everything else. So I think, with all due respect to the judiciary and the fraternity, we'll have to change our mindsets and find time. Number of cases, the delays are on account of non-availability of the arbitrators concerned. They're far too busy or what have we. So we'll have to find time, allocate them, maybe have a special panels or something of the kind to be able to do it in a tighter frame.
Yes, please go ahead.
Sir, when we study this course in law school, or if you go to the marketing spiel of ADR, the thing is that it's going to be less costly, it's going to be speedier, and you're going to get to the result pretty quickly. I was looking at a survey that even in the United States, there is no evidence that actually ADR is any cheaper. Sometimes it is more expensive. But be that as it may, and if that is the reality, that's the reality, at least speed should attract us to this ADR. Otherwise, we will be again back in courts, and we'll be here 10 years from now in a similar conference trying to figure out why it didn't work.
Ms. Chandra, let me turn to you. There are really few options for us to establish the arbitration ecosystem here in India effectively. One is we take the longer road, India-led, Indian rules, and completely supported by the Indian ecosystem. This may take 5, 7, 8 years. Other is to tie up with somebody like ICC or SIAC, get their processes, get their expertise, get their administrative processes, hearing center management, and fast track this. This may or may not involve also accepting the rules of ICC or SIAC in India. So therefore it could be a franchise arrangement, it could be a revenue sharing arrangement, it could be a joint venture. What is, in your opinion, the way forward for India? I mean, we are going to see ICADR, which is a Delhi center set up. Should we be requesting the government to look at ways and means to accelerate the process by way of international expertise, and perhaps also a stamp like a SIAC or ICC or LCIA? And let me also remind you, LCIA came and set up a center here, and they have closed it down and are now going to deal with Indian arbitration back from London. What is your suggestion in this regard?
There is really need for all our organizations to be first reflecting on their own methodologies of working. And I just want to quickly mention what we've done in the National Highway Authority to give you a perspective. So one, we've issued clear instructions down the line that all disputes have to be nipped in the bud, because we realize that a dispute which is not settled at the grassroots level, because all disputes, say for instance infrastructure, are in the field, and they ought to be resolved there at that. There is a methodology for that, it is enshrined in the agreements. But most often, even though we have an independent engineer who is a neutral referee between the authority, which is the government, and the private party, the contractor or concessionaire, the independent engineer is meant to resolve the disputes, but most often disputes don't get resolved at that level. So one, we've issued a very clear directive that you have to nip them in the bud, because we realize that there is a money value to time. And anything which is allowed to just linger, festers, the costs on both sides become much higher, the risks become much higher, and parties can go bankrupt. Third, we have an institutional mechanism called the ISAC, or the Independent Settlement Advisory Committee, which we felt the need for. And this works as an alternative dispute resolution mechanism, as a conciliation mechanism which can be approached at any time. This is headed by a retired High Court judge. It has a retired Secretary to the Government of India and a retired DG of the Roads Department, because he's a technical expert. Any party can, if he is affected by a dispute at any stage of the proceeding, whether it is in the High Court or whether it is before the arbitral tribunal, post-arbitral award, pre-arbitral award, can approach this for a conciliation. And we have found that this has, and we've eased their rules of working. We've allowed them to call the private parties for a discussion. We've allowed our officers to give them notes and to do background analyses and research for them. And we found that out of some 20,000 crores worth of claims, we've been able to settle a large part of them for as much as little or as much as about 15 to 20% of the original claim value. And this is working quite all right. Sometimes, of course, private parties are not agreeable to this, which is a different matter. As regards an institutional mechanism which is such as the ones that you mentioned, yes, I think there is a need for setting up such forums, because big ticket cases would need to bring in and would need to be settled through the AGs of such bodies, such international bodies, and I think they would bring in a little more credibility than perhaps the routine methodology and the routine forums that we have. So I think that's a welcome idea.
I think the other point that I'd like to probably ask Harsh to clarify or sort of add his own views about is on the grounds to challenge an award. Already the amendments of last year by the Parliament has narrowed down the scope. Are you generally satisfied with what we have, or would you like to see this being further tightened, narrowed, expanded?
Well, from the first read of whatever brief note I saw, I think it seems to be fairly reasonable. However, such a test would only come about once we experience how the bottlenecks actually come about while we navigate this new law. So I don't have any specific suggestions except to say that to introduce a concept of interim relief would be something worthwhile in the Arbitration Act, and I think we'll just have to wait and see how these things move.
Ms. Roy, about creating a cadre of specialists as opposed to just pure legal minds in arbitration panels, what would your view be, and would you favor panels which have specialists of those particular areas that are under dispute?
Well, most certainly this would be able to ease out the current tensions that we have, because one of the very practical constraints of being able to resolute in this arena is that we don't have exposure to a person who can do both the sides. I think technical specialization as well as legal specialization and expertise, what we need is essentially a combination. What we have is actually watertight compartments of either, and either in very heavy doses is not good. But I do realize that it is often very difficult to, have a blend of both. So apart from creating a database of technical specialists, an idea which could be worked upon is something which I've done myself after coming into this industry, is that there must be a panel which is also technically sensitized, is perhaps technically literate to be able to deal with certain aspects of technique. And of course, they would be essentially from legal discipline, so that making an award or being able to argue with these awards out. But all of this would really make a difference only if we have arbitrators with teeth. Muscularity is something which we are now desiring to see amongst arbitrators. We have been very pained with processes where there has been too much silence in the arbitrator panel. And of course, it's with all due respect to the people who do it, but for a litigant, this is a process which must address a grievance. And too much is left to the final stages. We want more interim redressal of grievances. So yes, all in all, a technical panel is very much needed, because they can't be divorced from legalities.
Thank you. I think at this point in time, I will turn to the audience here. I'm sure there must be lots of questions, comments that need to be offered. So please identify yourself if you can, and then point your question to any of the panelists.
Yeah. Respected Chairman. Namaskar, sir.
May I have the lady first, and I'll follow it with you, please.
Please.
Thank you. Hi. My name is Sakshi. I've been studying international dispute resolution, and I understand we are here to discuss arbitration and its enforcement in India, but I got the hints from Mr. Ghosh and Ms. Roy, and it was explicitly discussed by Mr. Chandra. And my point here is maybe our efforts are misplaced. We all talked about conciliation and how that is actually what is practically being used by industry people here, and the business has actually found ways maneuvering around the laws and its problems, and instead of sitting and waiting for the change to happen, is this what the industry is doing now? Are they looking for other options in which they do not need the government to intervene or sort of support? Is it something that is already in place in NHIA, as you said, or in Indigo Airlines? And if it is already there, what do you think about putting some efforts there in terms of, we all know that mediation is not really regulated, and you mentioned the word conciliation. Is that something we can take it further instead of putting all our efforts into this one basket? Thank you.
I think just to reframe your question, I'll ask Mr. Chandra and maybe Aditya to answer it. Your view is that rather than putting entire thrust behind just ADR in terms of arbitration, you are talking about mediation and conciliation. I don't think so. They are being discussed in one over the other. I think all of them will be necessary for a country like India. But maybe Mr. Chandra can add.
I would agree with the view that they are not mutually exclusive and they form part of the larger basket. And the idea is to settle a dispute. How you arrive at settling that requires a certain level of confidence and compassion, and I would say empathy, which needs to be built into the system other than the procedural framework. And I think that is where we need to evolve ourselves as a country.
Could you just hold your thought? We'll just have Mr. Ghosh answer this, and I'll then come to you after another question which has already been.
Sakshi, right? Yeah, so very true, Sakshi. Look, we as business people, it's water flows towards whatever is the path of least resistance. And we try to come up with resolutions too. Now, having said that, I'm also very cautiously optimistic that this new law and this new amendment provides that base structure, right? That if for whatever reason that fails, when you go to the next step, it is speedy and there is some finality. The other piece that, I think Rohini, Ms. Roy mentioned it a couple of times, applies to us also, that even in the stage of the conciliation, when we are all consulting lawyers for sure, there needs to be a greater degree of presence of experts, subject matter experts, and law firms will, I think, also develop in that on that aspect, where when that conciliation discussion is going on, there are people who understand the technicality and the speciality and the really peculiarities of an industry, along with the laws that apply horizontally across all sectors. I don't know if that answers your question, but I think you're on the right track.
Gentleman at the back, please. Yes.
So, Namaskar. This is C. Anil Goyal, Independent Director, Rights Limited. Actually, I have seen in a few cases that attitude of the judiciary is to welcome this challenge. Actually, how we are going to cope with that, that is the main thing. Instead of rejecting the challenge, they are welcoming this. Please.
I take it as a comment and not a question. So may I turn to Ajay? You had a question?
You briefly touched upon the grounds for challenge of an award, and I think it didn't get discussed much, but I want to pose something to industry here, and we've got some fine judiciary here as well. This whole issue of public policy, on which many decisions have been written. As you do more and more cross-border transactions, you will be entering into contracts involving foreign law, involving foreign jurisdictions, and often those awards will have to come back to India. The question is, A, from industry standpoint, and then I want to ask the question whether you would prefer it to have been better defined in the law or at least have some clear judicial guidelines. How would you respond if you entered into a contract under a law which permitted exemplary damages or punitive damages, which is clearly not permitted by Indian contract law, which limits it to direct damages? Would you expect the courts to protect you when the award came into India? It's an awkward question, but I think it's important because this is where the maximum number of disputes, Sunil, I see happening now. Whether you look at Tata Docomo, fixed price transactions which violate FERA or FEMA. We've had old decisions which have said FEMA is a fundamental part of Indian law. But would you have preferred, A, what is your reaction generally? Would you say to your counterparty that you ought to know that we have public policy and therefore this is clearly not enforceable? Beyond that, would you have preferred greater clarity in the law, or would you at least hope that there will be some very clear judicial parameters laid down over a period of time?
Well, Ajay, I'm not going to wade into the Docomo Tata case here at all. But let me pick up the other one, which is probably less topical and controversial.
Sir, I have a question.
Just hold on, please. Antrix Devas, the issue, I can tell you, it has riled a lot of people in the government. And being a subject matter of my area, telecommunications, I've kind of looked into it. It really looks odd that such a large damages have been awarded against India. And therefore the question does arise, and how does the country protect its sovereign rights to deal with situations which are not in consonance with its own provisions of law or policy? And we will keenly await the outcome of the Docomo Tata case as to what comes out. But clearly, as I said before, an award should be an ATM type of a situation. You get an award from a recognized body, you should be able to tap into and cash it. And if it goes to the court, there should be very limited grounds on which it can be challenged. And I think the new amendment that has come last year has truly narrowed it down, and the courts do recognize and respect that. But equally, whether it's a FEMA issue that comes into play or some other policies or laws of the country that get into effect, gets impacted by execution of the award, is really beyond my pay grade, and I really can't comment on that. I don't know whether anybody else, Mr. Chandra, you would like to? Anybody else?
I would like to make a suggestion.
Yes, please go ahead.
No, basically, when we are talking about arbitration and to make it more enforceable, then the more emphasis should be on the commercial courts also, because under the Commercial Court Act, arbitration also has been taken. So I think to increase the number of judges dealing with commercial matters would definitely help the industry as well as the government of India to show that we are serious about implementing our laws, and therefore we should do in a more effective manner.
I think this is again a suggestion for creating more capacity in various forms and shapes, and I would only say that this is a welcome comment, and we take it in the positive spirit.
So may I?
May I take the gentleman here, please? Could you have the microphone on? Yeah.
Mr. Chandra and Mr. Roy, under the new amendment, section 12, subsection 5, you are not allowed to appoint your officers, past or present, or any consultants in your organization as arbitrators. So that limitation was not there for government organizations. Under your standard form of contracts, you always had one of your officers, either past or present, appointed as arbitrator. So with this change, how do you look at this change? What are your views? How does that affect you?
Yeah, I think that's a perfectly acceptable change, and there's no reason why we should hanker after our own officers being part of the arbitral tribunal. As long as it brings about neutrality, and as long as overall process is, value neutral, I think it's a positive step in the right direction, and it will prevent us from a natural urge or a natural tendency, individuals apart, to choose our own officers to be there. So I think it's a welcome move.
So, to deal with your question more specifically from my perspective as well, I also mentioned that it's been quite some time that we have discontinued the policy any which way before the Act actually made the amendment. But the concern still remains. I'm not sure whether this move or this shift from appointing your own people, ex-personnel, to outside experts has really fed in the kind of neutrality that we are looking forward to. And there is a concern which we have as a corporate house, depending on one of our recent experiences, concerning neutrality. There are provisions, you would have seen they've adopted the IBA guidelines now, and a lot of this is adopted verbatim from the guidelines. They have set out guidelines where the independence of these arbitrators would have a certain mechanism to be able to judge. However, when we try, we have had experiences because India is a very culturally connected community. So a lot of our legal professionals, even the juristic community, they know each other. There is a very strong familiarity between the two communities. And when we have the Indian fraternity in some of our disputes, very often the levels of closeness are a little disturbing to litigants. We are still trying to overcome that. We've had cases in the recent past where we've tried quoting these guidelines to be able to come to a fair analysis. And it's not fair, we realize it, because, there is a limit to how much, after all, the juristic community is not really a closed community. They have to socialize. But it does create an impact. I think in general, as people, we need to have that bent of mind and ethic that when we are looking into arbitral forums, a certain amount of separation of powers has to exist. Sorry, I heard the bell. Please continue.
The gentleman here at the back. Your voice is not audible.
Sir, I'm K. Mahesh. I'm Special Secretary Home in Delhi Government. We are talking about arbitration in construction sector, the airlines. Why we are not talking about the MSME sector, which is so important, which generates so much of employment and for exports. Under the MSME Act, there is a provision that these MSME units can move the government for arbitration and conciliation. So do you think there's going to be an amendment to the MSME Act to make an express provision, keeping in view, keeping it in, to align it with the new amended Act 2015? And secondly, can we have arbitration in tax matter? Any of the panelists can take up this issue. Thank you.
Take a shot.
Sorry. I really don't have an answer to that. I have no view on this particular subject.
Sir, can I, sir? Hello.
Yes, the gentleman is standing.
Sir, I am Naresh. I come from Gujarat and I practice at the district court level. So the execution of decrees, execution of arbitral awards, they come to me and we file execution petition in the district court. So my suggestion is that shortage of judges is not the only problem. The thing is that our judges are required to be educated. Since 42 years I am in the practice, and my experience says that most of the judges before whom I have been appearing, they don't know the relevant provisions of Arbitration Act, and they take it so lightly. So for execution of awards, it takes 2 years, 3 years, 4 years. That's the thing. So I think on this something should be done.
But sir, maximum judges are from bar. High Court and Supreme Court judges are maximum from bar.
We are not criticizing anybody. We are discussing the problem and solution. We are not criticizing.
No, noted your comments. The lady at the back, please.
Sir, kindly 1 minute, sir. 1 minute. Only 1 minute. Very vital linking to this point. I think for the last 2 days, we have just discussing Arbitration Act in isolation. We have forgot there is above one more law, supreme law, that is Constitutional Law of India. We have to read this Arbitration Act. Specifically, what are the provisions under the Constitutional Law of India? If any of the provisions, if we go, so many provisions are there which is unconstitutional. That will not go in depth, but there are so many provisions, those are unconstitutional. First thing, you already said, respected chairman, you mentioned clearly, Honorable Supreme Court judgment. What they said, you read it, sir, you quoted. Arbitration is the curtailment of the power of the Supreme Court. Now, any executive, legislative, these are wonderful words of wisdom of our learned and experts panels, and saying, promoting arbitration, that is there. But how executive, legislature, anybody can overrule our constitutional provision and the Honorable Supreme Court judgments? Thank you, sir.
The lady.
Sir, I have a question.
Just hold your thought. We have the lady. She'll be.
Hi, I'm Pragya from Mumbai. My question is that we've all, as India, we're still struggling to embrace ADR as a possible and a fruitful method to resolve disputes. So, coming from the private sector or the public sector, I just want to know that how fully convinced are these sectors of mediation really being a way of resolving disputes while we are still struggling or convincing ourselves to believe in arbitration? And my second question is that we've been discussing several factors that are potentially acting as a slowdown in India, for arbitration in India. So does that make you want to opt for arbitration outside of India and make that a more attractive or a cost and time effective option?
Well, as I mentioned right in the beginning, the issue of going into international jurisdictions or seats of arbitration is really basically because of the non-agreement or disagreement between two parties which will not agree to a particular jurisdiction belonging to one side or the other. And therefore, you end up being in Singapore or London or Paris or even New York. The reason for that is you all try to choose neutral jurisdictions between the two parties. Now, that is what I mentioned right in the beginning. If we can create enough reputation and credibility of our system over the next few years, we could overcome that particular issue, and maybe, possibly, some of the foreign companies, contracts may subject themselves to Indian rules of arbitration.
Sir, can I?
Yeah, we will really have time for...
Just one.
Really? One question? Just one question.
Sir,
we will...
Sir, I am Rashesh Parikh from Ahmedabad. Sir, my question is to Mr. Mittal. Based on your experience in India as well as now as a chairman of ICC, do you see any change in the quality as far as the arbitrator and advocates appearing for the parties, both in India and abroad? Because we are talking about thing that we are talking about international commercial, but do we have quality in India that we can match up with the overseas?
You know, honestly, I'm not the right person to answer you on the Indian side because I don't have much of arbitration issues in India. But as the chairman of ICC, I can tell you there's a continuous effort by the court in Paris to impanel experts, judicial minds, retired judges, legal eagles, and that particular panel just keeps on getting richer and richer, and that is also resulting and showing in the cases or the cases piling up into ICC almost every year getting more and more. So I would say international bodies like SIAC, ICC, etc. are continuously scouting around for more talent, right talent, appropriate knowledge-based individuals to add to the repository. In India, as I said, we are just starting this process, and hopefully in the years ahead we will have significantly better experts, we will have retired judges, we'll have a plethora of new people entering this field as people start to take more and more faith in the Indian arbitration system. Let me end by just concluding a few points. I think what we have discussed here today is that speed of enforceability and heightened sanctity by the government and the judiciary is absolutely a must. We need to have mindset change amongst all stakeholders to adopt arbitration as a way of life. And we need to develop a cadre of specialists to handle complex industry-specific disputes beyond legal fraternity. We've also heard today that arbitration is not the end-all and be-all. We will also look at other alternate settlement mechanisms or dispute resolution mechanisms like Lok Adalat. We look at conciliation and mediation and the commercial courts, etc. I think we've had a very engaging, wonderful session, and I'd like to thank my co-panelists and hand it back to Renee.
Thank you very much. Thank you very much, Mr. Mittal, Ms. Roy, Dr. Singhania, Mr. Neothia, Mr. Ghosh, and Mr. Chandra for that really interactive and informative session.